The day I became the most hated man in a community of 400 families was the same day I discovered they were all living on my grandmother's land. 1,000 acres, paved roads, houses, swimming pools, parks, an entire miniature town built on the inheritance she left me. And the woman running the HOA looked me straight in the eye, smiled politely, and said, "You have no rights here whatsoever." What she didn't know was that I had inheritance documents, 60 years of continuous ownership history, and enough patience to flip through every single page of records until her entire empire of fake paperwork collapsed in court. If you're watching this video while hiding from another mind-numbing HOA meeting, drop a comment below telling me where you're tuning in from. I guarantee this story will keep you glued to your screen. The GPS said I had arrived, but nothing in front of me made sense. I pulled over to the side of the road and stared through the windshield at what should have been my grandmother's land. 1,000 acres of rural property that she had owned since 1963. The same land where I spent summers as a child catching fireflies and listening to her stories on the porch. Instead of empty fields and the old farmhouse, I was looking at a neighborhood. Hundreds of houses lined paved streets with names like Meadow Lane and Sunset Drive. There were sidewalks, streetlights, a community pool visible in the distance, and a large stone sign that read, "Welcome to Meadowbrook Estates, a covenant-protected community." Children rode bicycles past manicured lawns. Sprinklers hissed in synchronized patterns. It looked like any other suburban development, except for one detail that made my stomach drop. This was supposed to be mine. I drove slowly through the entrance, past a guardhouse where a security officer waved me through without stopping me. The roads curved through clusters of homes, each one newer and more polished than anything my grandmother could have built. I counted at least 300 houses before I stopped counting. At the center of the development sat a large building with a sign identifying it as the Meadowbrook Community Center, home of the Homeowners Association. I parked in the visitor lot and sat there for a long moment, trying to process what I was seeing. My grandmother died 4 months ago. Her will was clear, everything went to me. Her only grandchild. The probate court had confirmed the transfer. I had the deed, but I did not have an explanation for how an entire town had appeared on land that no one had ever sold, transferred, or given permission to develop. I walked into the community center and asked to speak with whoever was in charge. The receptionist made a phone call, and 5 minutes later, a woman in her early 60s emerged from a back office. She wore a gray blazer over a white blouse, her silver hair pulled back in a precise bun. Her smile was warm, but her eyes assessed me like a problem to be managed. "I'm Diane Crawford, president of the Meadowbrook Homeowners Association," she said, extending her hand. "How can I help you today?" I introduced myself and explained that I had inherited this property from my grandmother. I showed her the probate documents, the deed transfer, and the will. She glanced at the papers with the patience of someone who had seen this before. "Mr. Gray, I understand this must be confusing for you, but Meadowbrook Estates has been an established community for over 15 years. We have 400 families living here, paying dues, raising children. Our records are complete, and our legal standing is secure." I asked her what records she was referring to. She tilted her head slightly, the warmth in her smile unchanged, but something harder settling behind it. "Perhaps you should consult with an attorney before making any claims that might create unnecessary difficulties for yourself. These situations can become quite complicated, and I would hate to see you waste time and resources on a misunderstanding." Her tone remained pleasant, but the message was clear. This is not your fight to win. I asked her directly, did the HOA ever purchase this land? Was there a deed transfer, a contract? Any record of a legitimate transaction? Her smile didn't waver. Mr. Gray, I'm not going to discuss legal matters in a lobby. If you have questions about property records, I suggest you visit the county clerk's office, but I can assure you that Meadowbrook Estates operates entirely within the law." She nodded once, a dismissal disguised as courtesy, and walked back to her office without another word. I drove to the county clerk's office that afternoon and spent 3 hours in the records room. What I found, or rather, what I didn't find, changed everything. My grandmother's chain of title was unbroken. She had purchased the land in 1963, paid property taxes continuously for 60 years, and never sold, transferred, or encumbered a single acre. There was no sale, no transfer, no consent. The county records showed no transaction of any kind between my grandmother and Meadowbrook Estates, the HOA, or any developer. According to every official document on file, the land still belonged to the Gray family. But when I searched for Meadowbrook Estates documentation, I found something that stopped me cold. The HOA's founding documents listed its address on property described as formerly unimproved land acquired through community development agreement. No seller was named, no purchase price was recorded, and the entity that supposedly authorized the development was listed as the Gray Family Trust. I sat back in my chair and read that line again. The Gray Family Trust. My grandmother had never created a trust. Her will made no mention of one. Her attorney, who had handled the probate, had confirmed that her estate passed directly to me with no intermediary structures. Someone had invented a trust that didn't exist, used it to claim authority over land they didn't own, and built an entire neighborhood on the lie. I photographed every document in the file, my hands steadier than I expected. Diane Crawford's confidence made sense now. She wasn't worried because she believed her position was legally sound. She was confident because the lie had worked for 15 years, and she assumed no one would ever check the foundation it was built on. That evening, I received an email from the Meadowbrook HOA. The subject line read, "Invitation to Resolution Meeting." The message was brief and polite, expressing the board's desire to clarify any misunderstandings and inviting me to attend a meeting the following week. It was signed by Diane Crawford, with a CC to someone named Neil Bridges, listed as HOA Legal Counsel. The last line caught my attention. "We are confident that this matter can be resolved amicably, and we look forward to demonstrating the strength of our community's position." It wasn't an olive branch. It was a warning dressed in hospitality. They were inviting me into a room where I would be outnumbered, outmaneuvered, and pressured to walk away quietly. What they didn't know was that I had already seen the hole in their foundation, and I had no intention of walking away from anything. The resolution meeting was held in the Meadowbrook Community Center's main hall, a space designed for holiday parties and neighborhood gatherings. When I walked in, I understood immediately that this was not a meeting, it was a performance. The room was packed. At least 200 residents filled the rows of folding chairs, and more stood along the walls. At the front, a long table held Diane Crawford, 2 men I didn't recognize, and a stack of binders thick enough to stop a bullet. Behind them, a projection screen displayed the Meadowbrook Estates logo. Every seat faced forward, and every face turned to watch me enter. I was the only person in that room who wasn't already convinced I was wrong. Diane stood and welcomed me with the same polished warmth she had shown in our first encounter. She introduced the man to her left as Roger Stanton, Vice President of the HOA Board, and the man to her right as Neil Bridges, the association's legal counsel. Neil was younger than I expected, maybe mid-40s, with the practiced stillness of someone who spent his career making problems disappear through paperwork. He nodded at me once, then opened one of the binders with the ceremonial weight of a priest opening scripture. "Mr. Gray," Diane said, her voice carrying easily through the silent room, "we appreciate you accepting our invitation. We understand that inheriting property can be an emotional process. Our goal today is to provide clarity and, hopefully, resolution." Neil took over from there. He didn't walk me through documents, he buried me in them. Binder after binder landed on the table. Incorporation papers, development agreements, tax records spanning 15 years. He flipped through pages without pausing for me to read, each turn reinforcing the same message. This was too big, too established, too documented for one person to challenge. The individual contents barely mattered. What mattered was the weight, the volume, the absolute confidence with which he presented them. "As you can see," he said, sliding a bound summary toward me, "Meadowbrook Estates was established through proper legal channels under a community development agreement authorized by the Gray Family Trust." He paused, letting the room absorb the words. "We have 400 families who purchased homes here in good faith. Any challenge to our legitimacy would not only fail legally, it would cause tremendous harm to innocent people." I looked at the faces in the audience. Families, retirees, young couples holding hands. They weren't villains. They were people who had bought homes, paid mortgages, and trusted that someone had done the paperwork correctly. The woman in the third row whispered to her husband. A man near the back crossed his arms and shook his head slowly. The room's sympathy was not with me. It was with the community that had existed for 15 years, the community that had block parties and holiday decorations and a sense of belonging that I was threatening to destroy. I understood then why Diane Crawford smiled so easily. Her power didn't come from being right. It came from 400 people believing she was. Truth was irrelevant when perception was this strong. Roger Stanton leaned forward, his voice softer than Diane's, but no less deliberate. "Mr. Gray, we're not unsympathetic to your situation. Losing a family member is difficult, and discovering complications in an estate can be overwhelming. That's why we'd like to offer you a path forward that benefits everyone." He slid a single sheet of paper across the table. "The HOA is prepared to offer you $75,000 as a gesture of goodwill in exchange for a full release of any claims against Meadowbrook Estates and its residents." $75,000 for 1,000 acres. My grandmother had owned for 60 years, for land worth millions, for a lie that had been running since before I knew it existed. I picked up the paper and read it slowly. The language was clean, professional, and airtight. It required me to acknowledge that I had no valid claim to the property, that the Gray Family Trust had properly authorized the development, and that I would never pursue legal action against any party associated with Meadowbrook Estates. Signing it would mean accepting that my grandmother's legacy was worth less than a mid-range sedan. I set the paper down and looked at Diane. "The Gray Family Trust doesn't exist," I said. "My grandmother never created one." The room stirred. Diane's smile didn't falter, but something shifted behind her eyes. "Mr. Gray, I understand you may have questions about the trust structure, but our legal team has thoroughly vetted every aspect of our founding documents. If there were any irregularities, they would have been discovered long ago." Neil Bridges produced a document with an elaborate letterhead. "This is a certification from the original development attorney confirming the trust's authorization." He held it up for the room to see, then set it in front of me. I looked at the signature at the bottom, dated 16 years ago, supposedly signed by an attorney I had never heard of, certifying a trust my grandmother's own lawyer confirmed never existed. The paper looked official. The language sounded legitimate, but official and legal were two very different things. I didn't argue. I photographed the document with my phone, thanked them for their time, and stood to leave. As I walked toward the door, Diane's voice followed me. "The offer won't remain open indefinitely. Consider what's best for everyone involved." I paused at the door. 200 faces watched me, waiting to see if I would fold. "I'll be in touch," I said. And I walked out into the parking lot, where the afternoon sun felt nothing like the warmth of a community that wanted me gone. That night, I sat in my hotel room staring at the photograph of that certification, a trust that didn't exist, an attorney no one had heard of, 15 years of homes built on a signature that supposedly made everything legal. The entire structure of Meadowbrook Estates rested on one piece of paper, and if that paper was fraudulent, then every document Neil Bridges had stacked on that table was worthless. It wasn't just a lie, it was a system designed to make the lie look like the truth. I searched for the attorney's name. I found an obituary first. He had died 11 years ago. Then I found his state bar record. His license had been suspended 3 years before that. The reason was listed in plain language that made my chest tighten: document fraud. The first letter arrived 3 days after the meeting. It was printed on Meadowbrook Estates letterhead, addressed to me at my hotel, and signed by Roger Stanton in his capacity as Vice President of Community Standards. The subject line read, "Notice of Trespass Violation, First Warning." According to the letter, I had entered Meadowbrook Estates without authorization and failed to register as a visitor at the guardhouse. I read it twice, trying to understand how attending a meeting I was invited to constituted trespassing on my own land. A second letter followed within the week, this time from Neil Bridges, adding claims of harassment and intimidation based on multiple complaints from concerned residents. No specific incidents were described, no complainants were named. The accusations existed only on paper, but that was enough to make them real in the eyes of anyone who read the file. The third communication was not a letter, but a legal filing. Neil Bridges had submitted a petition to the county court requesting a temporary restraining order against me, citing a pattern of harassment and unauthorized entry onto private property. The filing included copies of the 2 previous letters as evidence, along with 3 signed statements from residents claiming they felt unsafe due to my aggressive behavior at the community meeting. I remembered the meeting clearly. I had spoken calmly, asked reasonable questions, and left without incident. But the statements described a different person, entirely confrontational, threatening, unstable. The restraining order hearing was scheduled for the following week. If granted, it would legally prohibit me from entering Meadowbrook Estates, from setting foot on land that belonged to me. That filing changed how I understood the fight I was in. The HOA wasn't trying to prove they were right. They were trying to make sure I never got the chance to prove they were wrong. Every letter they sent became evidence of my pattern of behavior. Every filing they submitted painted me as the aggressor before I could establish myself as the victim. They weren't building a defense, they were building a wall. And if I kept reacting to their moves instead of making my own, they would lock me out of court before I could ever present my case. The restraining order wasn't about safety. It was about silencing me through procedure. That realization was the turning point. I stopped defending and started documenting. I photographed every letter, every envelope, every postmark. I created a timeline of every interaction with Meadowbrook Estates, cross-referenced with hotel receipts, gas station transactions, and phone records that proved where I had actually been. Then I shifted from documenting their attacks to dismantling their foundation. I spent 2 days researching the legal requirements for what they claimed to have done. The results were damning. A community development agreement required recorded consent from the property owner, consent my grandmother had never given, because no such document existed in any county archive. The Gray Family Trust, which supposedly authorized the entire development, had never been filed with the county within the required 60-day window because the trust itself had never existed. And every permit, every approval, every piece of paper that made Meadowbrook Estates look legitimate traced back to a single certification signed by an attorney whose license had been revoked for document fraud years before his death. The architecture of the lie became clear. It wasn't a single forged document. It was a system designed to make fraud look like bureaucracy. Each piece of paper referenced another, creating a closed loop that appeared legitimate to anyone who didn't trace it back to its origin. The HOA had spent 15 years reinforcing that loop, adding layers of meeting minutes and tax records, and resident agreements until the foundation was buried so deep that no one thought to question it. But foundations don't disappear just because you build on top of them. I needed someone who knew how to dig, someone who understood land law well enough to navigate the maze the HOA had constructed, and aggressive enough not to be intimidated by their tactics. I found a name that night, Helen Roberts, a property attorney 2 counties over who specialized in title disputes and cases against developers. Her reviews mentioned battles with HOAs, municipal governments, and even state agencies. She had a reputation for being thorough and relentless. I called her office the next morning. The receptionist asked what my case involved. I said I had inherited 1,000 acres and discovered an entire neighborhood had been built on it without my family's knowledge or consent. There was a pause. She said the attorney would call me back within the hour. Helen Roberts called in 40 minutes. The first thing she said was, "Tell me about the trust, every detail." I walked her through everything: the fabricated Gray Family Trust, the dead attorney with the revoked license, the chain of documents that all pointed back to a signature that should never have existed. When I finished, she was quiet for a moment. "Mr. Gray, if what you're telling me is accurate, you don't have a property dispute. You have evidence of systematic fraud, but we need to move carefully. Right now, they're building a case to make you the defendant before you can make them one. That restraining order isn't about protecting residents, it's about controlling the narrative." She asked me to send everything I had collected. I did. Her response came that evening, a single paragraph that made me read it 3 times. She had searched the county's archived permit records, not the active files, but the storage archives that predated digital conversion. The original development application for Meadowbrook Estates included a surveyor's report that flagged significant boundary discrepancies between the proposed development site and the recorded property lines. That report had never been included in the final permit approval. It had been filed, acknowledged, and then buried. "I'm trying to locate the surveyor now," Helen wrote. "If he's still alive and willing to talk, We may have found the thread that unravels the whole thing. The HOA thought they were burying me in paper. They didn't realize I was learning how to excavate. Helen Roberts found the surveyor. His name was Henry Caldwell, 73 years old, retired for 8 years, living in a small town about 90 miles from Meadowbrook Estates. He had worked as a licensed land surveyor for over 4 decades, and 16 years ago, he had been contracted to survey the property that would become the development site. Helen called him first to confirm he was willing to talk. We drove out to meet him the following Saturday, and what he told us over coffee in his kitchen confirmed everything I had suspected and revealed something I hadn't. Henry remembered the project clearly. He had been hired to survey 1,000 acres for a proposed residential development. When he completed his work, he found a significant problem. The property boundaries in the development application did not match the recorded boundaries in the county land office. The site overlapped almost entirely with a parcel continuously owned by the same family since the 1960s, my grandmother's land. He flagged the discrepancy in his official report and submitted it with the permit application as required by law. A few months later, I drove by and saw construction starting, he said, his voice flat with the weight of something he had carried for years. I called the county to ask what happened to my report. They said they had no record of any boundary issues. That was when I knew something was wrong, but I had no idea how deep it went. Helen asked if he had kept copies. He had. Surveyors maintain records for a minimum of 10 years, but Henry had kept everything from his entire career. He retrieved the Meadowbrook file from his garage and spread the documents across his kitchen table. The survey map showed my grandmother's true property boundaries, clearly marked with coordinates from the original deed. Overlaid on that was the proposed development footprint. The overlap was nearly total. His report, dated 16 years ago, stated plainly that the development could not proceed without proof of ownership transfer or consent from the Gray family. That report had been filed with the county. And then it had ceased to exist in any official record. Helen photographed every page while I processed what this meant. Someone inside the county permit office had received Henry's report, understood its implications, and buried it. The development proceeded anyway. This wasn't just fraud by the HOA, it suggested institutional involvement. I asked Henry if he knew who had handled the approval. He didn't remember the name, only the office, the county planning department, overseen at the time by a commissioner who had since retired. There were rumors about certain developers having arrangements with certain officials, he said carefully. I never had proof, but when my report vanished, I stopped asking questions. He paused. Maybe I shouldn't have. We left with copies of everything: the survey, the report, the correspondence, his original field notes. Helen was quiet for most of the drive back. Finally, she spoke. This changes the case entirely. We're not just challenging the HOA's claim to your land anymore. We may be exposing a system, and the people who built that system may still have influence. We need an airtight case before we move publicly, because once we do, we won't be able to control what comes back at us. Her tone had shifted. This was no longer about winning a property dispute. This was about surviving one. The following week, Helen filed a formal records request with the state land office, bypassing the county archives that might have been compromised. She also retained Walter Pruitt, a consultant who had spent 30 years managing county land records before retiring. His specialty was detecting manipulation gaps, alterations, documents that didn't match their timestamps. He agreed to trace my grandmother's chain of title back to its origin and verify whether any legitimate transfer had ever occurred. If there's a gap, I'll find it, he said. And if there's no gap, then whatever documents justified that development are fabrications. He started immediately. While Walter worked, Helen prepared our response to the restraining order petition. She didn't just deny the allegations, she filed a counter motion, requesting that the court compel the HOA to produce all founding documents, including the original trust authorization, the development agreement, and any correspondence with county officials during permit approval. It was procedural, but strategic. It signaled that we were no longer defending. We were demanding answers. And buried in that demand was a warning. We knew there were documents they didn't want anyone to see. The HOA's response came faster than I expected, and it didn't come through the courts. It came through the newspaper. 3 days after Helen filed the counter motion, I walked into a gas station and saw my face on the front page of the local paper. The headline read, "Inheritance Dispute Threatens Meadowbrook Community." I stood in the aisle and read the article twice, my hands going cold. It quoted Diane Crawford extensively, describing me as a distant relative who had suddenly appeared with dubious claims that could displace hundreds of innocent families. It mentioned the restraining order petition as evidence of my erratic and aggressive behavior. It painted a picture of a peaceful community under siege by a greedy outsider trying to destroy everything they had built. My name was spelled out in full, my photograph taken from somewhere I couldn't identify. Possibly the parking lot after the community meeting sat beside the headline. The article didn't mention the buried surveyor report. It didn't mention the fabricated trust. It didn't mention that the HOA had never legally owned a single acre of the land they claimed. It only mentioned me, framed as a threat to 400 families who had done nothing wrong. I bought the paper and sat in my car for a long time, staring at my own face. Until that moment, the fight had been private documents, attorneys, strategy. Now it was public, and in the court of public opinion, the HOA had just fired the first shot. The newspaper article was only the beginning. Within 48 hours, the story had spread into regional news sites and community forums I had never heard of. Someone created a page called Protecting Meadowbrook Families that featured my photograph, my full name, and a narrative that grew more distorted with every share. I was called a con artist trying to steal homes from innocent families. Another post claimed I had a history of targeting elderly property owners, a complete fabrication that was repeated as fact within hours. The specifics didn't matter. What mattered was the speed. The story moved faster than any correction could follow, and by the time I understood what was happening, the version of me that existed online bore no resemblance to the person I actually was. The restraining order hearing was scheduled for Thursday. When I arrived at the courthouse, a small group waited outside, maybe 20 people. Not the mob I had feared, but enough to feel like a wall. They held signs that read, "Save our homes" and "Stop the land grab." A woman I didn't recognize looked directly at me and said, loud enough for everyone to hear, "How do you sleep at night?" The group was small. The weight of their certainty was not. Inside the courtroom, the gallery was filled with Meadowbrook residents. Diane Crawford sat in the front row wearing a somber blue suit, her expression carefully composed into something between concern and sorrow. She looked like a community leader bearing a heavy burden. I looked like the burden. Helen had warned me this would happen. "They're not trying to win the restraining order," she said before the hearing. "They're trying to win the audience." She was right. The HOA's attorney presented testimony from 3 residents who claimed to feel threatened by my presence. He described my behavior at the resolution meeting as aggressive and intimidating. When Helen cross-examined them, their stories collapsed under basic scrutiny. None could describe specific threatening actions. And their timelines contradicted each other. But I watched the faces in the gallery. And I knew the facts didn't matter to them. The image had been planted. The truth would have to fight uphill from here. The judge denied the restraining order, citing insufficient evidence. It should have felt like a victory. Instead, it felt like surviving a wound that would keep bleeding. Outside, the crowd had grown slightly. Someone threw a paper cup that hit my shoulder. Helen walked beside me, her jaw tight. "Keep moving," she said quietly. "Don't engage." We reached the car and drove away while someone photographed my license plate. I watched them shrink in the rearview mirror and realized that none of them had ever questioned whether Diane Crawford was telling the truth. They didn't need to. She had given them someone to blame, and that was enough. The professional consequences arrived 3 days later in a single email. My largest client, a company I had worked with for 2 years, terminated our contract effective immediately. The message was brief and apologetic. Reputational concerns and potential complications. No specific accusation, no opportunity to respond. Attached was a link to the Meadowbrook news article. $17,000 in pending work, gone in one paragraph. The financial impact wasn't gradual. It was a door slamming shut. That night, I sat alone in my hotel room with the television off and the curtains drawn. The silence was complete. I ate dinner from a vending machine and watched the parking lot lights flicker through a gap in the blinds. This was my life now, a rented room, a dwindling bank account, and a fight that seemed designed to exhaust me before I could ever reach the finish line. I thought about calling Helen and telling her I was done. I could sell the legal claim, take whatever settlement the HOA offered, and disappear into a life where no one knew my name. It would be easier. But then I thought about my grandmother, who had held on to that land for 60 years through every kind of pressure because it was hers. Walking away would mean letting the people who stole from her win, not because they were right, but because they had made being right too expensive. I called Helen the next morning. "I'm not quitting," I said. She was quiet for a moment, then, "Good, because Walter finished his title search last night." Her voice shifted, carrying something I hadn't heard before, controlled urgency. "Your grandmother's chain of ownership is unbroken. No gaps, no transfers, no encumbrances. Every document the HOA used to justify its claim traces back to that fabricated trust certification. There is no legitimate basis for their presence on that land. None." I asked what that meant for the case. Helen paused. "It means we have everything we need to destroy their legal position. But there's something else, something that explains why they've been so aggressive." She told me what she had found buried in the HOA's recent court filings. 3 weeks ago, while I was still trying to understand the scope of the fraud, the HOA had quietly filed a motion to quiet title a legal action that, if successful, would officially declare them the owners of the land by default. The motion was based on a claim of adverse possession and continuous community use. If I failed to respond in time, or if I was too distracted to mount a proper defense, the court could rule in their favor without ever examining the underlying fraud. The deadline for the response was in 19 days. Everything clicked into place. The newspaper article, the courthouse crowd, the online attacks, the termination of my contract, none of it was about winning public opinion. It was about running out the clock. They needed me demoralized, distracted, and financially drained while a legal deadline approached that I wasn't supposed to notice. The reputation assault wasn't the goal, it was the cover, and they had almost succeeded. If Helen hadn't been watching their filings, if Walter hadn't finished the title search when he did, I might have surrendered before I ever knew what I was surrendering to. Diane Crawford hadn't been fighting to defeat me. She had been fighting to make me disappear before the truth could surface. 19 days, Helen said. That's what we have to file our response, present our evidence, and force the court to examine what they've been hiding for 16 years. They've spent all this time trying to bury you. Now, we bury them. I looked at the stack of documents on my hotel desk, Henry's survey, Walter's title report, the photographed trust certification signed by a dead and disbarred attorney. For the first time since this began, I wasn't just surviving, I was ready to fight back. Helen called an emergency meeting at her office the following evening. Walter Pruitt was already there when I arrived, documents spread across the conference table. Helen stood at a whiteboard where she had drawn a timeline with dates, names, and arrows converging on a single box labeled Gray Family Trust, crossed out with a large red X. "We've been building pieces," she said. "Tonight, we put them together." Walter started with the chain of title. His research was complete. My grandmother's ownership ran unbroken from 1963 until her death. No gaps, no transfers, no encumbrances. According to every legitimate record in the state system, I was the sole legal owner of 1,000 acres. There is no document anywhere that transferred any portion of that property to the HOA or any developer, he said, sliding a bound summary across the table. None exists because none ever occurred. Helen picked up from there. She had obtained copies of every document the HOA had filed with the county at over 16 years. Every one of them referenced the same source of authority, the Gray Family Trust, and every reference traced back to a single certification signed by attorney Richard Dawes, who died 11 years ago, whose license had been suspended 3 years before that for document fraud. The certification was legally worthless the day it was created, Helen said. But that's not why we're here tonight. She turned her laptop to face me. On the screen was the trust certification I had photographed at the resolution meeting, enlarged to show the signature. Below it was a paragraph from a forensic document examiner's report. Helen read it aloud. The signature on the questioned document is inconsistent with authenticated exemplars and displays characteristics indicative of simulation or tracing. It is my professional opinion that this signature was not produced by Richard Dawes. The room went silent. I read the paragraph twice. The trust certification wasn't just invalid because Dawes had been disbarred. It was a forgery. Someone had fabricated the signature. Someone had created the document from nothing and used it as the foundation for an entire community. Every permit, every deed, every mortgage in Meadowbrook Estates rested on a piece of paper that had never been real. Who forged it? I asked. Helen shook her head. We don't know yet, but we know who benefited, and we know who defended it for 16 years. Walter added the final piece. He had cross-referenced the original development permits with Henry Caldwell's survey. The permit application used coordinates that didn't match any property the applicants could legally claim. Henry's report had flagged this before construction began. Someone inside the county permit office had received that survey, understood what it meant, and approved the development anyway. I found the approval signature, Walter said. A deputy commissioner named Alan Torres. He retired 8 years ago, 6 months after the permits were approved. He purchased a vacation property paid in full. No mortgage. He paused. That doesn't prove he was bribed, but it's a question that deserves an answer. Helen circled Torres's name on the whiteboard. Here's where we are. Unbroken chain of title proving your ownership. A forged certification was used to justify the entire development. A buried survey that would have stopped construction, and a county official who approved permits he should have denied. Then came into unexplained money. She turned to face me. This isn't a property dispute. This is systematic fraud. The question is what you want to do with it. I looked at the documents on the table. The truth had been buried for 16 years in filing cabinets, in archived surveys, in the memory of a retired surveyor who never forgot that his report had vanished. Now it was sitting here, organized and documented, waiting to be deployed. The HOA had spent weeks trying to destroy my reputation and run out a legal deadline. They had assumed I would break before I found what they were hiding. They had been wrong. I want to go public, I said. I want every document entered into the court record where they can't suppress it. I want the judge, the jury, and every resident of Meadowbrook to see exactly what Diane Crawford built her community on. Helen nodded. Then we file our response to the quiet title motion tomorrow morning. We request an expedited evidentiary hearing. Once we're in that courtroom, everything we have becomes part of the public record. They won't be able to bury it again. She gathered the documents into a folder and checked her watch. The filing deadline is in 17 days. I can have us in front of a judge within 72 hours if we move tonight. She looked at me with something that might have been respect. They thought running out the clock would work, because it always had before. They've never faced someone with proof this complete. I thought about Diane Crawford sitting in that courtroom gallery, composed and confident, surrounded by residents who believed her version of events. I thought about the newspaper headlines calling me a con artist, the online posts labeling me a predator, the crowd outside the courthouse holding signs that said, "Save our homes." They had controlled the narrative for weeks. In 72 hours, the narrative was going to change. File it, I said, all of it. And Helen picked up her phone and started making calls. Walter began organizing the exhibits. I sat at the table surrounded by 16 years of buried evidence and felt something I hadn't felt since this began. Not hope exactly, but certainty. The fraud was documented. The forgery was proven. The chain of title was unbroken. Whatever happened in that courtroom, the truth was finally going to be heard. And Diane Crawford was going to have to explain how she built 400 homes on a signature that never existed. The expedited evidentiary hearing was scheduled for Thursday morning at 10 o'clock. When I arrived at the courthouse, the hallway outside the courtroom was crowded with Meadowbrook residents. I recognized faces from the resolution meeting, from the restraining order hearing, from the online posts that had called me a predator. They watched me walk past with expressions ranging from hostility to confusion. None of them knew what was about to happen. The courtroom was smaller than I expected, designed for civil proceedings, not criminal trials. Judge Eleanor Marsh presided from the bench, a woman in her late 50s with reading glasses perched on her nose and a reputation for procedural rigor. Helen had warned me that Marsh was fair but impatient with theatrics. She wants facts and documents. Give her those, and she'll follow the evidence wherever it leads. The HOA's legal team sat at the opposite table Neil Bridges, flanked by 2 associates and a wall of binders. Diane Crawford sat in the front row of the gallery, dressed in a navy suit, her posture perfect. She looked like someone who had already won. Helen opened with a simple statement: I was the sole heir to my grandmother's estate. My grandmother had owned 1,000 acres continuously since 1963. There was no recorded sale, transfer, or encumbrance of any kind. The HOA's claim rested entirely on a trust certification, and that document was a forgery. She moved through the evidence without pause. The forensic examiner's report concluding the signature was simulated. Walter Pruitt's chain of title showing 60 years of unbroken ownership. Henry Caldwell's buried survey flagging boundary discrepancies before construction began. The permit approval signed by Alan Torres, who purchased a vacation home 6 months later. Each document entered the record in sequence, building a case that left no room for interpretation. The HOA's foundation didn't crack under scrutiny, it simply wasn't there. Neil Bridges rose for his response. He was composed, but his hands gripped the edge of the table. He argued that the HOA had operated in good faith for 16 years, that families had invested their savings in homes they believed were legitimate. He called my claims a cynical attempt to exploit technical irregularities. He never addressed the forgery. He never mentioned Richard Dawes or the buried survey or Alan Torres. He spoke around the evidence because he couldn't speak through it. The silence where his defense should have been said more than any argument could. Judge Marsh listened without expression. When Bridges finished, she removed her reading glasses and looked at him directly. Counselor, does the HOA possess any document proving legitimate acquisition of the property in question, any deed of transfer, any bill of sale, any recorded consent from the Gray family? The pause lasted 2 seconds. In that silence, everything shifted. Your Honor, the trust certification has served as the foundational document for... That's not what I asked. Marsh's voice was flat, procedural. Do you have any other document? Bridges looked at the table, at his associates, at the binders that suddenly meant nothing. No, Your Honor, the certification is our primary record of authorization. Diane Crawford stood up in the gallery. The movement was abrupt, the first crack in her composure I had ever seen. Your Honor, if I may address the court. Marsh's expression hardened. Mrs. Crawford, you are not a party to this proceeding. But Diane was already speaking, her voice rising with something between desperation and anger. The trust was authorized. I was told it was authorized. The attorney handled everything, and we relied on his certification. If there were irregularities, they weren't our fault. We built something real here. Marsh banged her gavel once. Mrs. Crawford, sit down. Diane stopped mid-sentence. The courtroom was silent. She stood frozen, realizing too late what she had just said. She had admitted relying on a certification she never verified. She had admitted the trust authorization came entirely from an outside attorney whose work she never questioned. She had confirmed, in open court, that the HOA's entire claim rested on a document no one had ever independently validated. Helen rose slowly. Your Honor, Mrs. Crawford has just confirmed that the HOA's claim rests solely on a document they never independently verified, a document our forensic expert has concluded is a forgery. Marsh looked at Diane for a long moment, then at Neil Bridges, then back at Helen. Her voice carried no satisfaction, only finality. I've heard enough. I'm granting the plaintiff's motion to dismiss the quiet title action. I'm ordering a full evidentiary review of all documents related to the founding of Meadowbrook Estates, to be conducted by an independent examiner appointed by this court. She paused. And I'm referring the matter of the trust certification to the district attorney's office for investigation of potential criminal fraud. The gavel came down. Diane Crawford sank back into her seat. Neil Bridges gathered his papers without looking at anyone. The gallery was still not the chaos I had expected, but a silence heavier than noise. 400 families had just learned that the ground beneath their homes might not belong to anyone who had ever claimed it did. The ruling wasn't a victory celebration. It was the inevitable conclusion of facts that could no longer be denied. I sat at the plaintiff's table and looked at the faces in the gallery. Families who had bought homes in good faith, parents who had chosen schools based on this neighborhood, retirees who had invested their savings in properties they believed were secure. They hadn't forged the trust certification, they hadn't buried the survey, they hadn't paid off a county official, They had trusted people who lied to them, and now they were staring at the consequences of that trust. Helen touched my arm. "We should go. The press will want statements, and we need to control the narrative from here." I nodded, but didn't move immediately. The legal victory was complete. My ownership would be restored. The fraud would be investigated. The people who had built this lie would face consequences they could no longer avoid. But as I watched a woman in the third row wipe her eyes while her husband stared at nothing, I understood that winning wasn't the end. It was the beginning of a different kind of responsibility. I had proven that Meadowbrook Estates was built on a forgery. Now I had to decide what happened to the 400 families who had been living on it. The criminal investigation moved faster than I expected. Within 2 weeks of the hearing, the district attorney's office had opened a formal inquiry into the trust certification, the buried survey, and the permit approval process. Diane Crawford was charged with fraud, conspiracy, and theft by deception. Roger Stanton, who had signed dozens of HOA documents citing the fabricated trust, was charged as a co-conspirator. Neil Bridges faced separate charges for filing fraudulent legal documents with the court. Alan Torres, the retired deputy commissioner, was subpoenaed to testify before a grand jury about the vacation home he had purchased 6 months after approving permits he should have denied. The system that had protected them for 16 years was now the system dismantling them piece by piece. Helen called me with updates as the case progressed. Diane had retained a criminal defense attorney and was negotiating a plea deal to avoid trial. The prosecution was offering 5 years with the possibility of parole after 3. Plus full restitution and a permanent ban from serving on any homeowners association or community board. Roger Stanton had already accepted a similar deal. Neil Bridges was fighting the charges, claiming he had relied on representations from his clients and had no knowledge of the underlying fraud, a defense that was complicated by emails Helen had subpoenaed, showing he had received Henry Caldwell's survey report and never disclosed it. Torres was cooperating with investigators in exchange for reduced charges, providing testimony about how the permit approval had been expedited in exchange for what he called consulting fees. The word he avoided was bribery. The prosecutors did not avoid it. The civil case resolved more quickly. The court formally restored my ownership of the full 1,000 acres, including all structures built on the property. Legally, I had the right to evict every resident of Meadowbrook Estates, demolish every home, and reclaim the land my grandmother had owned for 60 years. The HOA's attorneys had calculated the total value of the properties at approximately $47 million. Insurance claims, lawsuits against the original developers, and recovery from Diane Crawford's personal assets would take years to sort out. But the immediate question was simpler. What would happen to 400 families who had done nothing wrong except trust the wrong people? I spent 3 days thinking about that question. I walked the property not through the developed areas, but along the edges where my grandmother's original fence posts still stood, weathered and leaning but visible if you knew where to look. I thought about what she would have wanted. She had been a practical woman, not sentimental about land but fiercely protective of what was hers. She had also been fair. She never cheated anyone, never took more than she was owed, never confused justice with cruelty. I thought about the families in those houses, the children who had grown up there, the retirees who had invested their savings, the young couples who had scraped together down payments for their first homes. They were victims of the same fraud I was. The only difference was that I had lost land. They were about to lose everything. I called Helen on the 4th day. "I want to propose a settlement structure," I said. "Not for the HOA leadership, they can face whatever the courts decide, but for the residents." She was quiet for a moment. "What do you have in mind?" The proposal took a week to draft. I offered every current resident of Meadowbrook Estates the option to purchase their home at fair market value, with financing terms that didn't require bank approval, essentially. I would act as the lender, allowing them to pay over 15 or 20 years at reasonable interest. For residents who couldn't afford to buy, I offered long-term leases at below-market rates, with first right of refusal if they ever wanted to purchase. For the common areas, the parks, the community center, the pool, I established a conservation easement that would preserve them as public space in perpetuity, managed by a new homeowners association with transparent governance and independent oversight. The settlement required every resident to acknowledge that the original development had been fraudulent, But it did not require them to pay for crimes they didn't commit. The response surprised me. I had expected resistance, suspicion, maybe even hostility from people who had spent months believing I was trying to destroy their community. Instead, I received letters, emails. A few people stopped me in town to shake my hand. One woman, the same woman I had seen crying in the courtroom, found my contact information and called to thank me. "We thought you were going to take everything," she said, her voice breaking. "We thought we were going to lose our homes because of what those people did, and instead you're giving us away to keep them." I told her I wasn't giving anything. I was selling at fair prices with fair terms. She laughed through tears. "That's more than fair. That's mercy." I'm not sure mercy is the right word. Mercy implies forgiveness. And I haven't forgiven Diane Crawford or Roger Stanton or anyone else who built their fortunes on my grandmother's stolen land. They will face trial. They will likely go to prison. Their names will be attached to this fraud for the rest of their lives. Justice, in that sense, will be served. But justice for the guilty doesn't have to mean punishment for the innocent. The families of Meadowbrook Estates didn't forge the trust certification. They didn't bury the survey. They didn't bribe a county official. They bought homes and raised children and believed what they were told. Destroying their lives wouldn't restore my grandmother's legacy. It would only prove that I had learned nothing from the people who tried to destroy mine. The last document I signed was the deed transfer for the conservation easement. Helen witnessed it in her office on a Tuesday afternoon. When it was done, she looked at me with an expression I couldn't quite read. "You could have taken everything," she said. "Legally, morally, no one would have blamed you." I thought about my grandmother, about the fence posts still standing at the edge of the property, about the land she had protected for 60 years. "She would have blamed me," I said, "and I would have blamed myself. The land is mine now. So is the responsibility that comes with it. If you've ever had to choose between what you could take and what you should leave behind, you understand why the hardest victories are the ones that cost you the satisfaction of revenge.